I'm Jacqueline Armand, a solicitor and partner at IBB Law. This is a summary of a presentation which I have been making about wills for several years to carers. It is apt that I'm recording this in Carers Week. However, the issues raised apply to most people who need to make a will. We should all have a will. Equally important, we should have a will which is up to date. As solicitors, we do try to future-proof wills as much as possible. That's why we ask difficult questions, such as how you wish to leave your estate if you, your partner and your children all die together. But it isn't possible to cover every eventuality, so it is important to keep your will under review. I suggest that you revisit your will every 3 to 5 years, although it is unlikely that you will need to change it that regularly. Alternatively, if there is a significant change in your life or in the life of one or more of your beneficiaries, then that is another reason why you need to make a change. I will start with the reasons why you should have a will which is specific to your circumstances. In most cases, the intestacy rules are inadequate, especially if you are a carer. For a start, spouses do not receive everything. Currently, they receive £250,000, which would include the value of property, together with chattels, which are essentially personal possessions. The rest is split in half. One half goes to the spouse, the other half to children at 18. There are different provisions if you are not married or if you don't have children, for example, but there is no provision under the intestacy rules for unmarried couples. Equally, most parents do not wish their children to inherit assets at 18. There is no provision for a beneficiary with particular needs. So there is nothing to assist if your partner or spouse has dementia. Equally, there is nothing to assist if you have a child with a learning disability or mental health issues. Further, if your child is unable to manage money, or if you are in a second marriage and you both have children from a first marriage. A well-drafted will cover all of those situations, but also means that you can choose who the executors and trustees are. The executors are the people who deal with the administration of your estate. They complete the inheritance tax account, apply for probate, and distribute your estate. Trustees deal with any trust that you create in your will. Usually, the executors and trustees will be the same people, but they do not need to be. Choosing them is important, as they need to be able to understand their role, they need to get on with one another, and they need to be able to work in the interests of the beneficiaries. Trustees can be beneficiaries. A will also means that you can choose guardians if your children are under 18. But your will also means that if you are not married, you can ensure that you make appropriate provision for your partner. You can provide for other family members that you might wish to include, or charities. It also means that you can avoid passing assets directly to a beneficiary who is unable to manage those funds. If a beneficiary is mentally incapable of managing money, then unless somebody is already formally in place to manage that, such as an attorney, it is probably going to be necessary to apply to the Court of Protection to put a deputy in place. Those applications nowadays take at least 6 months and sometimes longer. If a beneficiary is capable but vulnerable, the capital could be at risk. If the beneficiary is in receipt of means-tested benefits, then any gift to them will probably mean that they lose those benefits. For a vulnerable beneficiary, benefits are often a gateway to other services. In the case of a beneficiary who is in a care home and perhaps in support from the local authority, then receiving a gift from you would probably mean that they have to pay privately for that care. A well-drafted will also means that you can make appropriate provision for a vulnerable beneficiary. In the past, it was not uncommon for parents to make no provision for a child with a learning disability. This was often because they wanted to avoid passing assets directly to that child, and there was perhaps no attorney or deputy in place, and perhaps they did not have proper advice about how a trust could be used. What happened in many cases is that the estate would pass to their other child or children, on the often unwritten understanding that the money would be used for the vulnerable child. The problems with this are that you are creating a secret trust, but there are no terms. The second is that on the face of it, you have made no provision for your vulnerable child, which means that a claim could be made on their behalf under the Inheritance Provision for Family Independence Act. Alternatively, there's no guarantee that the other children will use the money as intended. It might be that they get divorced, or they die, or they spend the money, and therefore the vulnerable beneficiary does not benefit. When you're making a will, it's also important to consider what other family members might do, especially when we're talking about your children. If there are grandparents, then they might want to leave a legacy to their grandchildren, but a legacy of, say, £10,000 to a vulnerable beneficiary who is in receipt of benefits might mean that they lose those benefits. There are many other reasons to have an up-to-date will: inheritance tax planning, or dealing with specific assets, in particular a business, or if you have assets in more than one country. But I'm concentrating on vulnerable beneficiaries. In most cases, a trust is the solution. In the past, trusts were often viewed as being only for the very wealthy and as a means to avoid tax. The changes to the taxation of trusts over the last 20 years or so means that they are often not as tax efficient as they were. But in the case of a vulnerable beneficiary, they still very much have a role to play. And in some cases, there are also tax breaks. As a method of protecting a beneficiary, whether that is due to their age, incapacity, or financial vulnerability, or the need to control or protect assets, then a trust may still be the best option. The type of trust will depend upon your particular circumstances and that of your beneficiary, and you do need to take specific advice on that. But I want to highlight two situations which I see regularly. The first is an older couple who are concerned about the cost of long-term care, and the second, parents with a child with a learning disability. Most of you will know that there is no inheritance tax payable between spouses. So nowadays it is very common for a married couple to leave their estate to the survivor on the first death, and then to children. For many, this makes a lot of sense, in particular from a tax point of view. But if your spouse is in care, or if they are likely to require long-term care if you die, then everything that you pass to them will be in the pot to pay for that care. For some, that doesn't matter. If you are happy that the survivor of you will have direct access to all of the funds and can therefore pay for the best level of care that is available, then this is an easy solution. But many people prefer to try to protect some of the assets, whether that is because they take the view that the state should pay, although that means the rest of us really, or because most parents want to leave something to their children. The reasons don't really matter. One solution here, which allows for the same tax exemptions to apply, is to leave assets into an immediate post-death interest trust. In other words, a life interest trust, which means that the survivor is entitled to the income, but they are not entitled to the capital that is in the trust. If the survivor needs care, then only the income is taken into account. The capital is protected. In many cases, the main asset is the home and will be held in both names. It is important to look at how you legally hold the property. There are two options. In many cases, you will be joint tenants. That means together you own all of the property, and on the first death, the property will pass automatically to the survivor of you. It doesn't matter what your will says. The alternative is tenants in common, where you will each own a specific share, which in the case of spouses will be 50% in most circumstances. To fully benefit from the type of trust I've been mentioning, you need to hold your property as tenants in common, so that when the first of you dies, you can leave your half share to the trust. Changing this is straightforward and would usually be done at the same time as you make your will. If the survivor remains in the home, Nothing changes because they are the only person entitled to benefit from the trust during their lifetime. If the survivor wants to move, then they can, but because there is a trust, the trustees would need to agree. Therefore, as I mentioned, you need to choose your trustees carefully. If the survivor requires long-term care and the house is sold, then they will receive their own half share of the property, but your half remains in trust, and your spouse will receive the income, but not the capital. Therefore, if the money is put into a bank account, they would receive the interest from it. If the money is invested, then they would probably receive dividends. The capital can be available to your spouse, but usually the trust remains in place until the survivor dies, and then it passes directly to your children. In this way, you are protecting a share of your estate, but you are also putting an appropriate trust in place for the survivor, as well as preserving the inheritance tax allowances. The second example concerned parents with a child with a learning disability. And here parents will have many things to consider. They will be concerned that their child does not have capacity to manage assets, and in many cases there is probably nobody else otherwise in place to do that. Any assets that they do pass to the beneficiary will affect entitlement to means-tested benefits. Also, the child may well be vulnerable if anybody else knows that they have money. There are a range of options depending upon the particular circumstances. The life interest trust that I mentioned might be suitable if the child has some capacity to manage money, but the entitlement to income is probably going to affect benefits. A discretionary trust was often used in this type of situation because it is very flexible. However, the taxation of those types of trusts is now penal, and they may also mean that your estate does not benefit from the new residence nil rate band, which is an additional inheritance tax allowance which applies in simple terms when you leave your home to your children. For these reasons, a disabled persons trust, or also known as a vulnerable persons trust, is usually the appropriate option, provided that your child is in receipt of either PIP or DLA for care at the middle or higher rate. This trust is not actually a different type of trust, but it is given special tax status because of the circumstances of the beneficiary. Essentially, so long as the funds remain in the trust, then benefits are not affected. The trust is taxed as if it was in the hands of the vulnerable beneficiary, which means that income would usually be taxed at basic rate rather than the higher rate applied to discretionary trusts. Whilst your children is alive, they will be the primary beneficiary, and very little can be given to anyone else. When your child dies, the funds in the trust will usually be paid out to your other children or to grandchildren, but that is a decision for you. This is a guide to the options, but you do need to take your own advice to decide what is right for you. We would be happy to assist with that, so if you wish to, please call us or visit our website at ibblaw.co.uk. Thank you.